But it's a call you have to make, isn't it?
We do, from time to time. A charity may well be of a magnitude of operations that might be comparable to some of the largest companies in Australia.
So you take the revenue of a charity into account?
Well, it may not be revenue per se. The financial structure of charities are typically different to a corporation, but a charity that was able to operate on an Australia-wide basis was visibly active in large-scale charitable activities in numerous simultaneous locations at once. You can imagine that the sorts of leadership expertise that they might require and therefore may need to reimburse for may be more significant than a more locally run single-purpose organisation.
So what you're saying then, Mr. Hardy, is that it's not unreasonable to assess as a benchmark in the marketplace, if you need to run an organisation with a multi-million-dollar turnover, with complex operations, you need to attract a good person to run the organisation well, and that should be commensurate with what they could get in the private sector.
If not necessarily the private sector per se, there's no rigorous benchmark test, but certainly it's a factor to be given some consideration. It is a element that requires some degree of judgment and often debate with the relevant entity if we're having that conversation with them.
But if that person was getting, but if it seemed to be disproportionate to the nature of the organisation and what someone, for instance, in the private sector could be getting, is that something you take into account?
Certainly.
Sure. Can I just, in terms of, and this, you may want to take this a notice both to Mr. Wilcock and Ms. Roussell and you, Mr. Hardy. If a person has a complaint about the runnings, the tax-free status of an organisation, it goes to the ATO. Because of the very nature of the ATO in terms of the privacy, the privacy foundation and the way that the ATO carries out its work, that complainant will never really know what happens to that, unless of course they hear about it publicly. Is that correct?
That's correct.
Is there any, in terms of the rulings and in terms of either under this ruling, 2005-21, or other rulings relating to charities, or indeed in terms of the status of the tax-free status of a religious organisation, is it something that is justiciable in the sense that it could be subject to a writ of mandamus or certiorari, in other words, saying someone bringing in an administrative law action saying you have not done your job to assess whether that this organisation has tax-free status? Is that something that could be the subject of a court action? And I'm asking, I don't know the answer. I wonder whether you could take that on notice or whether you could proffer an answer now.
I have to take it on notice, I think, and just to understand the question, this would be someone that had perhaps made some complaint or referred some information to the tax office, was concerned that we had taken no action or had been disregarded, and that they might take some action against the office for maladministration or failing to act upon information.
I would say maladministration. I'd say that it would be more a case of a writ of, we're just thinking of my administrative law from 30-something years ago, 35 years ago, that it would be a case of, 33 years ago, it would be a case of failing to act, a writ of mandamus and say we require you to act in this way to fulfil the requirements of a ruling or your obligations under the Act.
I would have to take it notice, but yes. My observation, just off my top of my head, would be that depending on the nature of the information, you would perhaps position the tax office or any other agency into being compelled to act perhaps to the expectations of a member of the public, and the public then start to direct the activities of the tax office if that was taken to its extreme.
No, I'm not suggesting that. I'm saying that you have, for instance, a ruling, and there could be, it might even be an action saying what processes have you, you haven't even begun to undertake the process. What the outcome will be is up to the tax office, but if the process has not been undertaken, whether that will be subject to a prerogative writ. Can I just ask you, Mr. Wilcock, in relation to your submission at page 7, you looked at international comparisons with respect to England and Wales. Have you got that
Yes,
paragraph
yes, Senator.
there. You made reference to the UK, England and Wales. You said, unlike the proposed bill, it does not require, that is the UK and the England and Wales position, it does not require a weighing of the benefits against any detriment or harm. Is that still your position?
My understanding, Senator, is that the arrangements in the UK certainly remove the existing, as it applies in Australia, the existing common law presumption of a public benefit in relation to the first three heads of charity, but it did continue, that Charities Act of 2006 effectively continued the existing common law in relation to a public benefit, and indeed later in our submission on page 17 there's an excerpt of the legislation that applies in England and Wales, and at paragraph 3 under the public benefit test you can see that any reference to the public benefit is a reference to the public benefit as that term is understood for the purposes of the law relating to charities in England and Wales. So that, I understand, is simply providing statutory backing to the existing or prevailing common law in relation to public benefit. And so the difference, as I understand, Senator, or what that sentence is attempting to say, is that while in England and Wales the common law in relation to public benefit has been preserved by statute, effectively the provisions in the bill that you have introduced move somewhat away from the common law of public benefit.
Well, can I just put you in, it wasn't a trick question, I just want, last night Ms Joanne Edwards, the head of the Status and Public Benefit Policy for the Charity Commission for England and Wales, and asked her a question I put to her, I asked her whether that means of necessity, if there is an inquiry into the public benefit an organisation provides, it could look at the issue of detriment in balancing whether the public benefit test is fulfilled. The response from Ms Edwards was, yes, the detriment and harm question is part of our public benefit test, and one of our key principles of public benefit is that any benefits that might arise to the public must not be outweighed by any significant detriment or harm. That is a fundamental part of the public benefit test, so we would look at that anyway in the course of considering public benefit for any organisation. Does that change your view at all, or is that not inconsistent with your view?
I think the point that we were wanting to make is that the common law in relation to public benefit is preserved under the English and Welsh legislation.
Which of necessity involves a look at that.
And what the common law of public benefit is, I won't go to. If anyone were to go to it on this side of the table, I'd be asking Mr Hardy to do so.
Sure.
Whilst the legislation that the committee is considering does not simply preserve the common law in relation to public benefit in the terms that the provision that I referred to on page 17 of our submission does.
But in answer
so the question then becomes, I suppose, what is the scope of public benefit under the common law, and how might that differ from the scope of public benefit that might be put in place if the bill that you have introduced were to be legislated?
But if...
and that's an open question, and indeed I think we would say, and either implicitly or explicitly throughout the submission, there is a concern raised about what the potential implications of the legislation might be, not just for the ATO but for regulated entities under it.
But Mr Wilcock and to Mr Hardy, thank you for that, but do you both concede that in the context of what the Charities Commission of England and Wales has said, that in order to determine a public benefit, it of necessity involves looking at any detriment or harm an organisation may cause?
I'm certainly understand that's the evidence they've provided to you, and they'd be much more well versed with their own legislation, so certainly I couldn't gainsay them. I guess I would be interested to understand, in the absence of talk about public detriment in their legislation, how they become aware of, or how they are empowered to secure evidence of detriment